Hi, everybody. My name is Maggie Riley. I'm the Immigration Law and Policy Analyst for Boundless Immigration. And I wanted to pop on today and spend a little bit of time talking about cannabis and how it can impact your immigration cases. I'm going to hang out for just a second and let a few more people join. This is a topic that piques a lot of interest for folks. There are a lot of questions about what the status of the law is, especially if you live in a state that is legalized for medical marijuana or recreational cannabis use. So going to wait a couple minutes here, let people jump on, and then we'll get down to talking brass tacks about cannabis and how it can impact your immigration case. So I think I will go ahead and get started here. Welcome to everybody who's already joined us on the East Coast in your late afternoon. On the West Coast here, we're just a little bit after lunchtime on April 20th, and we're going to be discussing cannabis and how it can impact an immigration case when you're deciding to come to the U.S. either on a visa, if you're applying for a green card, or if you hope to apply for U.S. citizenship in the near future. Yes, that's right. I am using the phrase cannabis. There are various reasons for that, but it is the term that is most frequently used when discussing the legalization policies around marijuana, which is what a lot of people are more familiar with. However, I will mostly be using the phrase cannabis. There are historical reasons for that as well, but also in my state, Washington State, we actually recently just passed a law that changes the word marijuana in all of our laws in the state to cannabis. So for me, Boundless, our headquarters are in the Seattle area, and so I'm used to using cannabis, so I will be using that word as we go through our conversation today. So to start out, my name is Maggie Riley, and I am the Immigration Law and Policy Analyst for Boundless Immigration. I am an immigration attorney by trade, but I don't represent private clients. I just work with Boundless, providing information to the public and educating people as best as we can about the U.S. immigration process and the policies, breaking news, and things that are occurring around that. As I've already mentioned, I'd like to spend some time talking about cannabis and immigration law today. And if we have some time, I'll also be fielding some questions from you all because this is usually a pretty popular topic. So, as I've mentioned, some states in the U.S. already do have legalized recreational cannabis. To date, there are 18 states where it's legal to use cannabis for recreational use, plus Washington, D.C. and the territory of Guam. Now, this is a smaller number than the number of states who have authorized medical marijuana use, which is just the use for various medical treatments. People are often familiar with this in the context of certain internal disorders, dealing with cancer, nausea, things like that. However, a much smaller number of states, as I mentioned, 18 have legalized for recreational use. So this is all well and good if you live in one of those states. For U.S. citizens, they can purchase, consume, and possess small amounts of cannabis. However, there are still conflicts between state laws and the federal laws, which are also the laws that govern immigration. So immigration is always going to be a federal issue. Congress has the full authority to write immigration laws. Like immigration is controlled by federal law, at the end of the day, drug laws and policies are also controlled by federal law. What this means is that even if you live in a state like Washington that has legalized recreational cannabis use, those state laws still conflict with the federal laws. And namely what we're talking about here is the Controlled Substances Act. Now, this was a big honkin' law that was passed in 1970 when Richard Nixon was still president. It was part of a broader Drug Crime Control and Prevention Act, and it also simultaneously established the categorization system that the DEA and the United States government generally still uses today when they talk about drugs. So if you ever hear about somebody referring to cannabis as a Schedule I narcotic, that's that categorization, under the Controlled Substances Act. Cannabis is scheduled under Schedule I, and so what this means is that the government thinks that it has no legitimate uses for medical treatment, for research, anything like that. Because of that, it is fully outlawed at the federal level. So this means you cannot use it, possess it, manufacture it, distribute it, move it between state lines. You can't aid and abet, meaning you can't help another person to do this. Now, obviously, this creates some interesting conflicts, especially in the context of, as I see someone has mentioned around investment. There's a lot of money to be made in American and Canadian cannabis firms and companies. But there are risks, especially if you're not a United States citizen. So, as I've touched on again, that federal law is going to be controlling. And so if you're not a United States citizen, there are going to be serious risks to your immigration status or your immigration applications if you get to dabbling in cannabis, be it either in personal recreational use or even through investing. So let's get down into a little bit about what that means. So just at a starting rate point, if an immigration officer thinks or has reason to believe that you have violated any drug law, this can make you inadmissible right off the bat. And what that means is that you can be denied a visa, you can be denied entry to the country. So even if you have an approved visa, when you arrive at a U.S. airport or other port of entry, you can still be turned away as inadmissible. If you are already in the country and you're a lawful permanent resident, you've already got your green card, certain drug crime convictions can actually make you deportable. Suspicion of violation of a drug law can also prevent you from establishing what the government calls good moral character, which is a requirement to become a U.S. citizen. In that case, generally, you're going to be looking at a 5-year period immediately before you file your citizenship application. However, all of these things are discretionary up to the USCIS officers, and so they can sometimes choose to look beyond that 5-year statutory period, especially if they feel that the crime in question or the conduct in question is more serious. And when I say conduct, I will mention that a conviction is not necessary to run into trouble under the immigration laws in the United States. So most of the time, people assume that you have to have been convicted of a crime to run into trouble. And if you have a green card, that's most likely going to be the case. However, any commission of an illegal act can jeopardize receiving immigration status or maintaining your immigration status, regardless of whether you're convicted. So if you were arrested or charged, even if those charges are dropped or expunged, this could land you in trouble that can affect your immigration status for years to come. This is why I really, in general, when I used to work with clients, and many immigration attorneys now will still very strongly caution, if you are not already a U.S. citizen, it's often a good idea to steer clear of the cannabis industry altogether, just to make sure you don't accidentally run afoul of a law, get caught up in some tricky questions, or otherwise jeopardize your status. Now, turning to investment, for example, this is one I touched on that can even jeopardize people who already have their green cards. So what I mean by that is you may remember that I mentioned the Controlled Substances Act talking about using, possessing, distributing, aiding, or abetting in the distribution of drugs. This includes cannabis, even in states where it is already legal. The other thing that this means, though, is that aiding and abetting in the distribution, manufacture, or sale of drugs includes investing in a cannabis company. There is some open question for investors traveling, for example, from places like Canada, whether or not they would be denied entry into the United States. At this time, it appears that CBP is allowing visitor entry if the purpose of the visit is not related to the cannabis industry. However, for immigrants who are already in the United States or are hoping to immigrate into the United States, either on a visa of some description, potentially an H-1B, TN, some kind of employment visa, but also folks trying to immigrate through their families and receive green cards, this can prevent you from being able to do that. And so having that investment is going to be risky. And in general, immigration attorneys are going to say steer clear so that you don't get into trouble with these sort of aiding and abetting in controlled substance trafficking laws. The law is very broadly written when it comes to drug trafficking or controlled substance trafficking, as it's called in the immigration regulations. It's very broadly written, which means that conduct you think might be inside the law, especially if you're living in a state where it's been legalized, could still get you in trouble with the federal controlled substances laws as well as the federal immigration laws. I'll also note that the stakes for this for non-immigrants are really high for family members as well. So if you have earned income through a cannabis-related business or through cannabis-related investments, and you end up being found inadmissible because of that, this can also prevent your spouse and your children from being admissible to the United States if they financially benefited from your investments. So for example, if you're a lawful permanent resident, you've invested in a cannabis company, and that income you are now using on your I-864 affidavit of support to immigrate your spouse or your children into the United States, that income is actually going to be considered illicit income. It's not from a lawful source. So in that case, it's actually going to bar your children and your spouse from being able to enter the country for 5 years. So again, these stakes are quite high. The consequences can be severe. And so to that point, I would also add, if you have already had an experience where perhaps you have used or possession of cannabis, if you have invested in a company, these aren't necessarily a kiss of death for your case, but you absolutely should speak with an experienced immigration attorney before traveling outside the country and before filing anything with the government, because you want to make sure that you're not going to run afoul of any laws, not get stuck outside the country and not being able to come back. So I think the only question I have caught so far was regarding whether or not it's all right for lawful permanent residents to invest in cannabis, which unfortunately is not going to be possible. In general, I do see a question about investing in general to immigrate, and that's going to fall under the immigrant investor visas, which is the EB-5 program. And the EB-5 program just had some changes made to it under a Reform Act that was passed earlier this year, which will actually raise the quantity of income that is required, revenue required to be invested to $850,000. Previously, I believe it had sat at, I want to say 500, it might have been 575, They did boost that number up though, so it does need to be a higher investment to receive that EB-5 visa. There is information available about the EB-5 investor visa on the Boundless website in our resource article section. So if you have more questions, I do strongly recommend you check that out and see if any of that is helpful for you. Sorry, I'm just scrolling a couple questions here. Is it possible to immigrate to the United States without a marriage? It is possible. There are actually quite a few avenues for folks to enter the United States. At Boundless, we predominantly work with families who are immigrating, and so that's why you'll hear me most commonly talk about spouses, children, and other family members. It is possible to immigrate through employment if you have an employer who's willing to sponsor you for a visa. In some cases, it's possible to immigrate on a self-petition. These tend to be religious workers. There are also self-petitions available for a group of people called Amerasian widows, as well as the Violence Against Women Act, which does allow self-petitions for people who have been harmed by a United States citizen. And that does, in fact, apply to men and women who have been victimized. So it is the Violence Against Women Act, but it does apply to men and women who have been victims of abuse at the hands of their U.S. citizen spouse. It's a really broad topic, so I won't go too much more into detail than that. Just to suffice to say, there are a lot of avenues available. Again, check out our resource section on Boundless. We do have a lot of articles about the different ways that people can come into the United States, and we do our best to share information about that. I encourage you guys to send in questions whenever you think of them, because that helps us think about how can we provide more and better information to you all. As far as, general immigration, often the best thing is the most common ways, again, are going to be through family and employment. And so that's a matter of finding somebody who's willing to sponsor you in the United States through a work. That is a topic that we don't touch on quite as much here. But again, I direct you guys to the website. I just want to make sure that you're aware that that information is there. And there are a lot of organizations that do work with people in varying employment, economic statuses, etc. So often the best idea is to get an idea about where you think you might fit in and then go from there. So do your reading, check out our site. And let's see. I want to see if we have any more questions relating to cannabis and immigration. I think the major questions, another one that we had received is people curious about how it might impact their medical exams. So if you are somebody who is or has used cannabis recently, Drug testing is a potential part of an I-693 medical exam, but it doesn't always take place. In general, the civil surgeon or the panel physician, whoever is conducting your exam, is going to have the option to ask for a drug test, but they generally will only do it if they have reason to believe that it is necessary. The standard generally is if the person is what is called a drug abuser, so has a substance abuse disorder or problem that may interfere with their health or their ability to care for themselves in the United States. Again, this is not something that all panel physicians check for, but it is always a possibility. And so that is something to keep in mind as you're preparing to submit an application or to file an I-693. So for folks that are looking to immigrate through a spouse or a fiance, if you are not already married, there is an option for what is called a K-1 visa, which is a fiance visa. So in that case, you have to show that you're engaged, that you intend to marry, and that you have met in the last 2 years. We do have a resource guide as well on K-1 visas on our website, so I would definitely encourage you to have a look at that. K-1 visas are something that Boundless and our sister company Rapid Visa are able to help folks out with. So there are possibilities to immigrate there even before you are married, as long as you do have that intention and you meet some other requirements. A student visa is also another great way that a lot of people enter the country. I think that's one I forgot to mention before. The most common is going to be an F1 student visa, but folks can also enter on J and M visas, which are vocational and exchange student visas. But again, typically you're going to see an F1 visa for students, especially community college or university age students. However, an F1 visa or another student visa is what is called a non-immigrant visa. So you have to have the intent only to come to the country temporarily to study on that visa. You can't use it just as a way to enter the country and get married. There are what's called a consular process for a CR1 or the I-130 process that can allow people to enter the country from outside, but generally it is not legal to enter the United States on an F1 visa with the intention of getting married. However, it is perfectly legal to get an F1 student visa, enter the country to study, and then from there circumstances may change, your immigration path may change. But if that happens, I strongly recommend that you talk with an immigration attorney. As with many other areas of immigration law, it's pretty technical. There are a lot of strange little unfortunate loopholes, and you would not want to work so hard to get your visa, come to school, get into the country, and then get caught and tripped up by something you weren't already aware of. And then I do see another question, how often do we do these live videos? We do try to do them every 2 weeks or so, but that schedule does shift depending on what is happening in the immigration space. How many other articles are we trying to publish, and sort of what the interest is. So if we're seeing lots of questions on a particular topic, we like to try to schedule something so we can answer those questions for y'all. Sorry, I'm reading a question that I just received. If somebody is already married and living in the United States, often they're going to be able to adjust status from inside the United States. It does depend on a few other factors. That's a very oversimplified response. Sometimes it can depend on how did you enter the country, how long have you been in the country, what is your status. There are times when the person may have to go back to their home country for a brief period of time while they wait for that green card application to process. But very generally speaking, if you're already in the United States and you're in a legal status, especially if you're married to a United States citizen, generally you can adjust status and remain in the United States. One of the added benefits here is while you're in the U.S., of course, you get to be with your partner during that time, but generally you should also be able to get an employment authorization document, which should allow you to work and in some cases attend school as well. I'm seeing questions about the CR1 backlog. Has it improved? I would say overall we're seeing pretty negligible movement, especially at the National Visa Center. So for folks who are immigrating from outside the country, doing that CR1 consular process, not doing adjustment of status on I-45 in the U.S. If you're coming in from out of the country, NVC, the National Visa Center, they are severely backlogged. They have been making some progress. We've seen numbers been inching down, but we're talking about half a percentage point here, 1 or 2 percentage points there. At this rate, some calculations we did at Boundless, it's looking like it's going to take many years, honestly, to get through that backlog, absent USCIS making some kind of aggressive structural change to how they handle these cases. That is a topic for another time. I've got a lot of opinions on how USCIS could speed things up. But I will say that we are seeing some improvement at USCIS as well on backlogs in some areas, but in others we're seeing, very serious struggles. For many of you who have been waiting, you're already aware that employment authorization documents are experiencing huge processing backlogs. Some folks are waiting over a year to receive that work authorization, which obviously has very serious consequences for that person, their family, and not to mention the knock-on effects to the local community and the economy, right? So this is a very serious problem that USCIS has been struggling under for several years, frankly, at this point. We saw some brief relief, I think, in 2020 where those processing times on EADs came down briefly. Unfortunately, we're back at anywhere between 7 months and a year at this point. So anytime we're talking about backlogs, there is going to be a bit of variation. Different forms are experiencing different backlogs. If you're dealing with the Department of Homeland Security and USCIS, you might also be, or otherwise you might be dealing with the Department of State and the NVC, who have separate processing protocols, separate backlogs, separate problems, unfortunately. So these things are going to vary also regionally. So, sometimes where you live in the United States can affect it, but sometimes it's just a matter of luck of the draw, which service center ended up with your form. And unfortunately, there's not really any control that applicants, or if you have an immigration attorney working with you, there's not really anything they can do about that. USCIS sort of decides where they're going to send their caseloads. And from there, it's you just sort of wait and pray to a certain degree. It's an unfortunate situation. I hate to break that bad news, but that is where we're standing right now on the backlogs. I'm seeing another question. So looking at investment visas and the time to U.S. citizenship, that's going to be pretty variable. And unfortunately, I don't have current information that I could give you off the top of my head on that timeline, particularly for the EB-5s. Part of the reason there is because the EB-5 program did lapse under the previous administration. Now, it was recently reauthorized, which is great news, especially for folks that already had green card applications pending under that program. However, because those cases were already in line and then were sort of just put in the freezer while the program was on hold, those people, I would presume, are going to take precedent over any new EB-5 investors who are trying to also join into that queue. So unfortunately, I can't really give you a timeline there. Honestly, you're probably going to be looking at, the employment visa backlogs are pretty substantial. And so without really looking at how the new EB-5 reform bill is going to impact that, I really would hate to guess and have wrong information. We are going to be releasing some updated information that my colleague Eric Finch, who's a former USCIS officer with us, had looked into around the EB-5. So keep your eyes peeled because I think that information is going to be helpful for you. Does cannabis usage affect approved green card status? So this is going to be a tricky one because if you were with us at the beginning, I spent a bit of time talking about how cannabis is still controlled by the Federal Controlled Substance Act. So technically speaking, it's always going to be a no-no, right? It's always going to be a violation of that federal law, which as a lawful permanent resident, you assert to the government that you're not going to violate any of the United States laws. And again, if you're an LPR, when you apply for citizenship, one of the questions that they're going to ask you is affirming the oath of the United States. So that's, are you going to, abide by and uphold the Constitution? Do you renounce fealty to other nations? And also, are you going to abide by the Constitution and the laws of the United States? And so in that context, even if you live in a state where legalization has occurred for cannabis, you're going to run into issues with the immigration question where it intersects with those federal laws. So technically speaking, yes, cannabis usage can affect your approved green card status. This is not legal advice. Obviously, we're not all hopefully being watched all the time. And so what happens in somebody's home, generally that's private, but at the same time, that is technically going to be a violation of the law, and that can in and of itself create issues. There is a small loophole for immigration that can prevent deportability if possession is under 30 grams. But, the state laws, it's always going to be a tricky area, and I would strongly encourage people to think carefully about the risks to their status, and especially if you hope to become a citizen, because you can do pretty serious damage to your case. So by and large, usually a good idea to steer clear unless you're a United States citizen, and that's going to include investing in those cannabis businesses as well. So I think we're running up against time here. I really appreciated all these great questions I've gotten from everybody. We will be releasing a video, the recording of this live later today. So if you missed the beginning or you had some information that you weren't sure that you caught, you can come back and catch us later. Also, go ahead and check out boundless.com, and you can check out our blog to see resources and articles we've posted on this. We have informational videos going up on our social media as well as our YouTube channels. And I look forward to talking with you guys again at our next Instagram Live. Again, I'm Maggie Riley with Boundless Immigration, and thank you guys so much for joining us today. Have a great day and stay safe out there, be smart, and take care. Bye, y'all.